Hi, Dan Krause here, attorney in Wisconsin, Minnesota, and Illinois. And today I want to talk a little bit about the disadvantages of having a will and going into court. I have a little story to tell you about something that I come across every now and then. But first, I want to tell you that if you are concerned about estate planning or elder law, there's a great newsletter that you should get in on. Email me or email Emily so that we can get you on our list. So you can email emily.rusch, that's R-U-S-C-H, at friendly.law. That's emily.rusch at friendly.law, and we'll get you on our newsletter list and get you a lot of good information. So here's something that has happened to clients or potential clients of ours several times, and I just want you to know that it can be avoided. It's something bad. So somebody dies, and if that's not bad enough, that somebody doesn't have any close relatives. So siblings are either deceased or they don't have any. They're an only child. The parents are deceased. They have no nieces, nephews, and nobody really knows where aunts and uncles or cousins might be, whether there are any. So this is a problem because anytime you die with assets, you have to notify the next of kin. And the next of kin is designated in the state statutes. It'll tell you who that is. The next of kin, it's not used that way in the statutes, but it's anybody that would inherit from you if you had no will and no plan. So even though you might have a will, like in this case, a man passed away. He had friends who he wanted to get his assets after he passed away. He got a will, perfectly valid and all witnessed and everything. But the problem is now that he has passed away, even though he gives everything to his friends and the relatives are not mentioned anywhere in the will, we have to find the relatives in order to give them a chance to object to the will. That's how the law works. So if you want to avoid that problem, this person could have avoided it by doing a revocable living trust. There's no requirement with the trust that you notify anybody that you've died, or that the person has died who created the trust. You don't have to go through the process of hiring a private investigator to look for unknown heirs so that you can check the box with the probate court and say that we've looked for the unknown heirs or we found these unknown heirs. The process of looking for unknown heirs is kind of expensive. You have to pay the private investigator, but not only that, you have to pay a guardian ad litem, who is an attorney that is assigned to represent the interest of the unknown heir. So if there are heirs that are unknown, they have to have representation, somebody to look out for their best interest. And that's also costly. So these are things that dig into the estate and make it so that you get to give less assets to the ones that you really want to. So if you have relatives that you don't want to get things, or close relatives that you don't want to get things, and you don't care whether they are notified that your estate is being administered, then you should get a trust instead of a will, because the will is going to require notice and opportunity to be heard after you've passed away. So that's just a little tip. Another good reason to get a trust, a living trust, a revocable living trust instead of a will. If you have any questions about these or other matters, please give us a call. Our number is 608-268-5751. Thank you very much.